What is the difference between aggressive driving and reckless driving? These are two different criminal traffic offenses that we have here in the state of Arizona. There's some pretty big differences between the two when it comes to the statutes. So let's take a look at it. What is the difference between reckless driving and aggressive driving in the state of Arizona? As a quick recap, let's talk about the different levels of misdemeanor offenses that we have in the state of Arizona. So we have civil offenses, those are just regular traffic tickets. We have felonies, those are the very, very serious offenses where you can go to prison if you get convicted of one of those. And then in the middle we have what are called misdemeanors. Within that category of misdemeanors, we have three different classes. So we have a class 1 misdemeanor, which is the most serious, a class 2, which is the second one in the middle, then we have a class 3, which is the least serious of the misdemeanors. So with that framework in mind, when we're talking about reckless driving, we're talking about a class 2 misdemeanor. It's right there in the middle. If you're convicted of reckless driving, the maximum penalty that you can face is 4 months in jail. You can face a fine of $750. Plus surcharges. You can be on probation for up to 2 years. Now, if you are convicted, the court is also going to notify the motor vehicle department. They're going to assess 8 points on your license. Arizona reports points out of state, so it's very likely that they're going to be reported back to your home state if you're not from Arizona. If you are convicted of reckless driving, we're going to talk about what how the law works in order for you to be convicted of that. But before we do that, let's talk about aggressive driving. So very similarly to reckless driving is a different statute. It's called aggressive driving. Kind of sounds probably kind of the same thing, but it is a little bit different. The statute requires some very specific conduct. So aggressive driving is a class 1 misdemeanor, unlike reckless driving, which is a class 2. So a class 1 is the most serious, a class 2 is one level below it. So if you're convicted of an aggressive driving charge, the maximum penalty is 6 months in jail versus the 4 months in jail for reckless driving. Fines $2,500 plus surcharges versus the $750 plus surcharges. Both of them have probation that's possible, 5 years for aggressive driving, 2 years for reckless driving. Aggressive driving, however, just like reckless driving, also has 8 points that could go on your record. If you're convicted of that, the MVD is going to assess 8 points, just like reckless driving. It's important to note that both of those offenses, both of them being 8 points, that's the same number of points as a DUI. So a DUI is a class 1 misdemeanor, just like aggressive driving is. Reckless driving has 8 points, just like a DUI does. So both of these are very severe. People are concerned about having these go on their record. So let's take a look at what the government needs to prove in order for a person to be convicted of either one of these. First and foremost, reckless driving. You can see here, I put that it is sort of the less strict of the two in terms of the elements that the government needs to meet. So when you're talking about going to criminal court, it's the government's job to prove certain elements in order to find you guilty of that crime. When you look at the law is going to basically say, if you do any of these things and the government finds beyond a reasonable doubt, or a jury finds beyond a reasonable doubt, or a judge finds beyond a reasonable doubt that you did those things, then you're guilty of it. So what are those things we're talking about? For reckless driving, if you look up the statute, it essentially says, I'm paraphrasing, that you can be convicted of reckless driving if you are conducting a motor vehicle in a manner that exhibits a reckless disregard for the safety of persons or property. So it's that key language there, reckless disregard. What does that mean exactly? It's very broad. You can hear just from the language in itself that it's really hard to define what that is. What is reckless? What is a reckless disregard? Well, it can vary. It's open to a lot of different interpretations. What my mother thinks is reckless is going to be different from what I think is reckless, or what's going to be different from what my friend thinks is reckless. All of us have different standards. And so on a reckless driving case, you have to have the jury or the judge, if you're going to do a bench trial, define what that is and then see whether the facts meet that. So basically they're going to look at the facts and they're going to say, okay, we think that that was a reckless disregard, therefore that person is guilty. But as you can see, it's very, very broad. Now let's contrast that with aggressive driving. So aggressive driving, the statute is much, much more specific. What we're talking about here, in order to be convicted of an aggressive driving charge, a person needs to be doing what's called criminal speeding. So they need to be speeding in a manner in which it's criminal. Either that's going over 85 miles an hour anywhere in Arizona, or it's going over 20 over the posted speed limit. So for example, 56 miles per hour in a 35 mile per hour zone would be criminal speeding. So if you are speeding criminally and you do two other things, any type of other moving violations really is what it covers, then you can be guilty of aggressive driving. So criminal speeding and, for example, following too close and an unsafe lane change, or swerving or weaving, or any one of those other moving violations, running a red light, blowing through a stop sign, failing to yield, any of those other violations are going to be covered by that statute. So it's speeding plus two other things is going to constitute aggressive driving. So you can see here now, if you can take an aggressive driving case, and actually go forward and present it in front of a jury where you can say, I was criminal speeding, but these other two violations just weren't in the facts. If you can review the dash cam footage or an officer's body camera footage, and you can show that maybe there was speeding, but those other two violations didn't happen. Or if you can say those two other moving violations did happen, but I wasn't speeding criminally, then again, that's another element. So aggressive driving is saying you got to do these three things. If you can invalidate one of them, then that's going to help you overcome that charge. Contrast that with reckless driving. So reckless driving, you have to prove, basically it's up to the opinion of the jury or the judge that the activity in the case constitutes recklessness. So it's kind of nuanced little distinctions there, but a lot of the time people are charged with both of these offenses, or they'll be charged with one, and the plea deal will be to reduce it down to another charge. So for example, a person can be charged with aggressive driving, and the plea deal will be to reduce it down from a class 1 misdemeanor down into a class 2 misdemeanor for the reckless driving. Another interesting thing is that aggressive driving, because of where it is in the Arizona revised statutes, it's outside of the purview of what's called a motion to set aside a conviction. It's the same as sort of a traffic offense, which you're not allowed to set aside. I have a number of different videos on what setting aside a conviction is. It's basically the closest thing that we have to expungement in the state of Arizona. So this is outside of the purview because of where it is in the statutes, whereas reckless driving is not. Reckless driving, you can get that set aside. So if you have kind of an opportunity to take a plea deal on one or the other, you may want to consider the reckless driving. It just depends on what the facts of your case are. So this is the difference between aggressive driving and reckless driving in the state of Arizona. People have this question a lot, so I wanted to hop on here and answer that so you have a better understanding of how it works. If you or somebody you know or love has been charged with either of these offenses, if you're trying to make a decision on what to plead to, if you're trying to determine what your odds are at a trial, if you're looking to speak with an attorney about any of that stuff, give our office a call. We offer free case evaluations. We'll have you come in, we'll set up a consultation over the phone and be able to really review your case in a little bit more detail so that we can help guide you through the process. It's a free case evaluation. You literally have nothing to lose. We look forward to speaking with you soon, and thanks for watching.